Hello, beautiful people. Welcome back. Still not convinced that 42 USC 1983 or the 18 USC 241 242 is really not where your right of claim is, where your right of action is. In the past, we've spoken about the fact that it was not ratified properly, and thus it's non-existent. We've shown that 18 USC 241 242 does not afford a private right of action. In the past, we went over the different types of right and different types of action. In the past, we went over the elements and tests of things like the Fourth Amendment, some parts of the Eighth Amendment, and we'll be going over more of that in the future. Most people are quick to jump to civil rights, specifically 42 USC 1983, and so on. How does the 14th Amendment substitute for Eighth Amendment being cruel, unusual punishment? Most people usually come and say, well, they've done this bad thing to me. It's cruel. It's not right. It's unusual. It's unlawful. So they invoke 14th Amendment by way of 42 USC 1983. When in truth, the 8th Amendment already covers that. We've also went over how the 14th Amendment is merely a rehash of everything else within the Bill of Rights, which is Amendment 1 through 10. And the fact that it was made for properties, citizens of the United States, 14th Amendment. If you're saying the United States is a fiction, if you're saying the United States is a fiction and it doesn't exist, well, they got a non-existent law called 14th Amendment. And oftentimes when you read case laws regarding the 15th Amendment, the ones that are successfully done, 42 U.S.C. 1983, they always pair it up with a private right of action during the Bill of Rights. Always. And whenever you hear any type of memorandum explain the details of 14th Amendment, 42 U.S.C. 1983, and how it can be viable, they will always pair it up with the private right of action during Bill of Rights. How does the 14th Amendment substitute for the 8th Amendment in pretrial detainee claims against municipalities for which failure to protect and condition of confinement, litigation, in correctional facility jails? The question is posed. 42 U.S.C. subsection 1983 does not create its own cause of action. Again, 42 U.S.C. 1983 does not create its own cause of action. So if this thing a lot of people try to use called the civil right 42 U.S.C. 1983 does not create its cause of action, that means you don't have a cause of action. That means you cannot state a claim upon which relief can be granted because it doesn't exist. We've went over why this doesn't exist. But here is another way of it being reiterated to you by a memorandum of publication. Traditionally, 42 U.S.C. subsection 1983 litigation has required, meaning we've known this to be a fact. Hence, traditionally, a tradition is something that's repeated and generally accepted as the norm. Do people who enforce 42 U.S.C. civil rights or talk about it or tell you to enforce it, do they tell you how it's traditionally and normally enforced? No, they don't. Traditionally, 42 U.S.C. subsection 1983 litigation has required, and this is a qualifying factor to this thing that does not exist because it does not create its own cause of action, has required that the constitutional violation be fettered by a Bill of Rights. There we go. Meaning, see, this thing called a Bill of Rights is called a Bill of Rights for a good reason. They just don't call it a Bill of Rights for any reason. A bill is in charge of a mandate to perform something. A right is something substantive that's being preserved that you can do or cannot do. Simple as that. The 14th Amendment is not part of the Bill of Rights. It's something else to its own. If people going about the United States being a fictional entity, a corporation who doesn't have jurisdiction, this and that, they're bankrupt, this and all that, then should that not tell you that 14th Amendment, which is specifically created for it, does you no good? And the subsequent statutes in harmony with that 14th Amendment that you're saying you don't fall under your jurisdiction, should that not tell you that it does not create its own cause of action? Even if you're not aware that it was not legally ratified. Here's another thing that's basically telling you it does not create its own cause of action. It does not stand by itself because it doesn't affirm, preserve anything substantive. And according to norm, it requires the support of the Bill of Rights, which affords you private right of action. as we've went over in the past. First, Fourth, Eighth Amendment, which we've went over the qualifying factors, elements, and standards of Fourth Amendment, some of it, and Eighth Amendment, some of it. There's a lot more. If you don't know the standard elements and tests to these things, there's no way you're going to go into any court and say somebody violated your rights and thus should be held liable. There's no way you would get into a settlement conference to get cut some type of check one way or the other. There's no way you can even start to think of putting someone else in prison. There's no way you can start to enforce a state common law regarding battery, assault, simulation of legal process, theft, all that, because the foundation is dead. And they're telling you, if you want to at least have some standing, tether it with Bill of Rights. So if the Bill of Rights is what even gives this standing in the first place, why are you even looking at 42 USC? Why don't you just go to the main thing that has substance in it? 42 USC 1983 does not create its own cause of action. Traditionally, 42 USC 1983 litigation has required that the constitutional violation be tethered to a Bill of Rights violation. First, Fourth, Eighth Amendment, which have built-in standards. Look at that. I always tell you that every right have standard, tests, and elements, and they're telling you which have built-in standards. I mean, the standards are now the specificity of how it applies to your circumstance and your ability to enforce those given rights. If you don't know the standard, test, and elements, you don't have any rights. 14th Amendment is not such a right in and of itself. Look at that. How much more clear can this ever be? They tell you 14th Amendment is not creating its own cause of action. They tell you the 14th Amendment is not such a right, quote, in and of itself. But the thing that does have the preservation of right is the Bill of Rights. I mean, they give you these things. It's called the Bill of Rights for a reason. Yet a lot of people just go over it and ignore it and go to other things. They're telling you in order for this thing that a lot of people go to call the Civil Rights, which is a subrogation of the 1866 version, which is the first one properly, which has not been annulled. It can still be used. In order for it to have standing, you must tether it with Bill of Rights. You must attach it to something of substance. To tether something is to basically just link it. So if you need this to have a standing by attaching it to the first 10th Amendment, which is the Bill of Rights, why don't you just go to the proper thing itself? Because every verbiage that exists in this already exists in this. The only difference is the jurisdiction of fiction versus the jurisdiction of equity. A lot of people saying they want to go to equity, but it already exists. And then they give you case laws regarding the details. Just another food for thought. It's a very short 3-page PDF that gives you very important keys. Someone would have studied thousands and thousands of PDFs and listened to hours and hundreds and thousands of hours of lectures and speculated for years. And all it takes is just a couple of lines to tell you, yeah, what you did, what you've been thinking is nothing. What you've been thinking you're doing and studying is nothing. Simplicity is the key to solution. And the dynamics is where it's at. I'll be uploading this file on the Patreon. Do your due diligence. If you don't want to do your due diligence or in furtherance of what you value as due diligence, look into it yourself. And then further clarifications and details are needed. Then you have to understand the value to it. By virtue of that, I'm inviting you to come and join my Patreon if you haven't. Over there we speak about things we don't talk about on YouTube. We speak about privacy, we speak about trademarks, the USPS, and how they use trademark products to basically subrogate you. We speak about things of spiritual nature. We speak about UCC related matters. We speak of how to sue people, audits. We speak of property rights, copyrights. We speak about child support, loans, commerce. We speak about the intricacies of the different types of corporation and how they use it against you. We go over the laws and the verbiage of copyrights. We go over how to create copyrights and trademarks, how to sue people, the intricacies of actual fraud, corporate veil, how it's used against you, how your trust cannot be pierced, the private side of court beyond the commerce. We speak of how to protect your asset and how to enforce it against people. We speak about discharge, different types of discharge according to satisfaction, how to go after their oath and bond, how to get their oath and bond, especially on a federal level. We speak of how to create private profiles. We speak of many things regarding privacy in the Fourth Amendment, how to sue them, the different types of suits and relief, how to establish probable cause. We speak about copyleft and how it's in fact full faith and credit. We speak about the common laws, public act, session laws. We speak of GSA bonds, how to fill them out, how to put your vehicle in trust, how to not qualify for taxation, and many good study tools, and many more to come in the future.